Please go on. Please go on.
Dear participants, this Saturday, if you see the schedule, we have Mr. Vikas coming back for a query Q&A session on financial modeling. So I hope you have some queries ready, and I request all of you to send such queries on the email ID, preferably by tomorrow late evening, say 8 p.m. or 9 p.m., so that the faculty also get some time to handle them in a more meaningful manner. It will help us to collate the queries, and then we will forward it to the concerned faculty, and so that they can be handled. So request all the participants, if you have any such queries, whatever questions you have, kindly share with us by tomorrow evening, preferably by 8 p.m. or rather before the class. What 8 p.m.? It should be before 6:30 rather. So with this, maybe we can start. The time is already on. Ojaji, few participants had some queries, so request you to kindly handle such queries also today. And over to you, Ojaji, please.
Thank you, Dr. Siroi, and welcome back, participants, to this session 2 today on the valuation of shareholder rights and discounts and premiums. So we have started this topic yesterday, covered some bit of ground, and today I intend to conclude this discussion with you for the time being. We will so pick up from where we left yesterday. I will also give a very short recap, just so that the context and the flow is retained. So we'll have a recap of what we discussed yesterday. And then, of course, very important, we have to deal with your questions. There are some very good questions which came yesterday and more during the day. So we will try and address these questions, and at the end we'll allocate some time for that. And if there are any further questions as we go along today, you can put it in the chat window. We'll try and pick it up. Just one more caveat, that in case after discussing the questions, if there are any other issues, any other queries, any other aspect you would want me to specifically address, you're welcome to kind of put these questions through the IICA platform, and I would be happy to respond to those in writing, or maybe in another Q&A session which we can devote to this aspect of the presentation. So idea is that while I have focused my presentation on the legal and the contractual and the regulatory aspect attached to valuation of shareholder rights in the context of applicability or the degree of discounts or premium. So in that framework, if there are any further questions, they are all welcome. We understand that some of these topics that we speak about are fairly vast, they're fairly intense, extensive. We try to compress it within the time that we have together. But of course, it's very, very natural for all of us to have some questions, some issues. And idea would be that this presentation would be meaningful if it is able to address each of your questions, in a logical manner. So that would be my objective. So in that sense, today is not a concluding day. I'm open to taking your questions. So with that little bit of a initial comment, let's quickly try and recap for the sake of continuity and good form of what we have already discussed and what we tried to lay out in the initial presentation yesterday. Yesterday we discussed primarily on the legal, contractual, and the regulatory aspects relevant to shareholder valuation, relevant to the valuation of shareholder rights in an enterprise. And today we will do the same. We'll continue the same thread today. We'll focus on the legal, contractual, and the regulatory realm. My presentation is not focused at the quantification or at the heart of how to attach values and all that. There are very eminent experts who would be addressing you and would address you on these aspects. Now, in this context of we discussed yesterday, and as relevant to shareholder valuation, we introduced the framework of the Companies Act. I did say that there is an overriding impact, overriding implication of the law, which has to be the entire the assessment and the valuation has to be within the four corners of that law when you look at contracts or articles or whatever. So we did highlight that. And then taking for the purpose of our discussion, we tried to identify and highlight certain feature of shares, which attach to shares and shareholding in an enterprise, as to what are these features and how these features get altered and how they then impact our valuation or impact our application of discounts in the valuation process. And then I did also indicate to you certain shareholder rights, very critical rights, which are relevant in the context of the valuation. Then we moved on and we spoke, we tried to analyze at a very generic level and then at a very specific level, what is the concept of shareholders agreement? We said that these are called by various names, but primarily shareholders agreement extend to ownership, management, and control. And we tried to go within each one of these aspects and we tried to see what could be the bespoke or what could be the standard terms which are usually found under each of these headings. And what are the effect of shareholder agreements on the company and the shareholders and the implications in law. From there, we tried to reflect and look at the shareholders agreement vis-a-vis the law, the Companies Act, and the articles. And we tried to and we established, we highlighted certain salutary principles as to what overrides what, and how do contractual rights, by being placed in the articles, how do they become more strong, enforceable for the company. I did pick up some of the basic Indian cases which have kind of delved around shareholder rights and share transferability restrictions and provisions of articles. And then in that frame, we concluded by saying that the Companies Act will prevail over SHA, and SHA cannot run contrary to the Companies Act. So if there's anything there which is contrary, it has to be read down. Now, what is contrary and what would be repugnant is again a aspect for determination on a case-to-case basis, and you have to look at it in the context of what the right is and what the law says and what the jurisprudence and say to this extent this is contrary. After having set out the premise of shareholders agreement and its legal validity, we then moved on yesterday and discussed about the concepts, the rationale, and the basis of discounts and premium in equity valuation. So we did try to see at what stage do these kick off in the valuation process? How do you approach it? And how are they relevant in our process of valuation analysis? Although there are, we said that there could be many other factors as well. But the two factors that we picked up for our discussion was the entire concept of transferability or marketability of shares and how it is related to the discount that is DLOM, discount for lack of marketability. And so we discussed that and then we moved on and did try to project DLOM at a greater level and see what are the features of DLOM, what factors impact DLOM, and how is it determined, and what are the things to be kept in mind while you are in your valuation analysis, doing both, trying to ascertain the applicability of the DLOM or trying to determine the extent to which it should be applied or Then we picked up the other concept of discount, which is related to control. So we said that one of the essential features of shareholder or a block of shareholder is their ability to control the destiny of the company. And to the extent that this control exists, there could be a premium, and absence of it could lead to some discounts. And in that context, we spoke about discounts for lack of control. And with for DLOC, we did talk about the features, the aspects, and the levels, at which DLOCs operate or are applied under the Companies Act, is taking up from absolute 100% ownership to 10%. We tried to discuss the various slabs of control, and how would the controlling interest be approached by the valuation experts like you gentlemen. And thereafter, very briefly, we tried to marry these two concepts and get them together, DLOC and DLOM, and discuss it as a composite kind of a concept as to how they are related, how they are distinct, what is the base for one, what is the base for the other, and how they should be applied, in a valuation exercise. So very briefly, I think in 10 minutes that has passed, I have summed up what we discussed yesterday. Now, what we are going to extend our discussion today to, first of all, we'll look at some jurisprudence and legal authorities which are relevant to the context of our discussion. That means, what are some seminal legal precedents concerning shareholder valuation and discounts. And when we look at this jurisprudence, I have tried to I will try to present to you in the context of the Indian cases, and thereafter, very briefly, in the context of some of the international cases. Now, keep in mind that, and as you all very well know, valuation itself is a very wide, it's a very vast subject. And if we delve into this subject and try to extricate the case law or the judicial precedents, there'll be many, there'll be huge number of cases that we'll look at. Now, what I have done is I have filtered these cases through in the context of our discussion: shareholder valuation, principles, and application of discounts or non-application of discounts. So I've tried to keep that framework while I'm trying to select some of these cases for you. I'm sure there are many cases, more cases than what we will be able to discuss within the time that we have. And I'll be happy to share a very comprehensive list of all cases with you if you would want to. So after discussing the Indian landmark cases and the international authorities, then we'll try to sum up the discussion. We'll try to sum up the discussion under two heads. One would be that what are the broad takeaways that we have from this 2-day presentation? And second, why is this in today's world, and more from a legal perspective, why is it necessary, and what are the ingredients and what are the various tools that a valuer will have to be careful of or deal with, while approaching share valuation. Today, I mean, we'll talk about it, but today we all know that there's a greater onus on the valuers as to the quality and as to the output of the valuation process. It's so that puts various I would say obligations upon valuers, which we need to be kind of aware of. So that's where I'll sum up. And then finally, we'll take up the questions. I do have your questions from yesterday and today, so we'll try and answer some of the questions. So now let's straight away talk of some of the Indian law on shareholder valuation and discounts. And I have selected some cases which I'll discuss with you. Now, we all know the famous Renuka Datla case. We all know it for various reasons, we have known it in various circumstances. There is, and when I speak to some of the valuation experts, I'm frequently told that this case added to the confusion rather than clear it. And I do not have my reasons, and I can't disagree with that. When I look at this case, it does bring out certain principles, but it doesn't take us much far. Let me make an opening statement, and this is a feature of the Indian jurisprudence on valuation. You see, for various reasons, the development of Indian judgments court legal precedents on valuation has been very slow. It has been very slow. It has been very sporadic, and it is very context oriented. So it's not that, as if suppose as lawyers we go to a field like constitutional law or contract law, and we find a very nice flow of legal precedents, and then you can use it together and develop a kind of a thesis that this is how the law has evolved. Sadly, it's not in the case of valuation. We do have certain cases. We do have in certain cases, in certain circumstances, courts have said something. They have, refrained from saying many things. So we try to put it together. But it is far short of a comprehensive legal jurisprudence on valuation of shareholder rights. It's just not there. Now, plus, you also know that Indian courts, the valuation issues have come up in different circumstances. There could be statutory requirement either under the income tax, FEMA, or various amalgamation, reorganization, mergers, and these are various facets in which valuation arose as a subset, and it was then reflected by courts. Another feature which I find is that, and which is now kind of gaining a lot of traction internationally, is that valuation is becoming also very critical in the context of dispute resolution. Typically, when you look at international disputes or arbitrations, we all know the concept of damages. Damages are claimed, damages are awarded. Now, frequently we find that there is a field of valuation which is branching into and flourishing and enriching itself in the field of economic damages. How do you determine economic damages? There is underlying company, there is underlying shareholders. So of course, the principles of valuation go in. They kind interact with the principles of legal principles of damages, and there is some kind of a valuation report. Specifically in the Indian context, we have very, very cases which deal with valuation of damages. We do have international cases, but this is, and again, this is a separate topic. We'll talk about it as to why we do not have Indian cases, which are on damage analysis and valuation of damages. It's a function of our evolution, of our, how they approach damages traditionally. So I think with that little overriding view, the first case that I spoke would be the Renuka Datla case, and this came to the Supreme Court in 2007. And what was the facts? I mean, basically, in the context of what we are talking, the fact was very brief. The respondent, the party there, wanted to purchase around 4.91% equity held by the other party in two companies. And both the companies for this purpose were valued as going concern by applying three methods of valuation. The valuation done by experts, and they had the asset approach, the earning approach, and the market-based approach. So for the purpose of this acquisition, there was underlying valuation on these three approaches. And one of the things that the court said there was that the intrinsic value of the share would be based on the asset and the earning based value. Since the value of a company's business would be more influenced by its earnings value, a higher weightage was given to the earnings value as compared to the asset value. So this is how, after applying the three methods. The weightage was allocated between the three, three methods. And because in that case there were huge discrepancies in the projections which were available, the DCF method was disregarded by the valuers. So they said that this is not a credible way to kind of proceed. So that was not taken into consideration. And in the valuation, no value was assigned to the controlling interest. So this 4.91%, there was no control premium or nothing assigned. And the reason that the valuer said was that in view of the fact that the party would own only 4.91% of the share capital, hence no weightage was given to control premium. One of the contending parties did say that if that look there was an existing block of shareholding, and if you added to this this 4.91, it would eventually yield control. That was a bone of contention, that for that you should have this incremental acquisition of 4.91% would provide yield control. So, so that was what was brought out. Of course, there was about some issue about valuation of brands, and that may not be relevant for today. So the issue was that what would be the intrinsic value of these two companies and the circumstances in which any premium for controlling interest could be added to the valuation, and the circumstances in which the value of certain brands could be added. So that came up for consideration in the Renuka Datla case before the Supreme Court. And broadly, it was a three-member bench looked at that case, and they held that the valuer had given relevant reasons for non-inclusion of the brand and was transferred. And they also said that there are no existing assets of the companies being valued. So even though the validity of the transfer was under challenge. So Supreme Court, in essence, upheld the the judgment or the that discretion employed by the valuer, and it said that no, you cannot invite valuers' attention to extraneous issues as regards the validity of the transfer or incidental matters. Fact that 4.91% by itself is not a controlling equity. So if the valuer assessed for reasons that that there should be no control premium, there's nothing wrong in that assessment. And then Supreme Court also said that look, there are no special rights attached to these 4.9% shares. Therefore, the claim for control premium was rejected. There was no, of course, there was no shareholder agreement or no special rights that came with this 4.9. They're just plain block of 4 shares. So the disregard of a control premium by the valuer was upheld by the Supreme Court. And in this case, the Supreme Court also discussed about a previous case, which was, CGT versus Kusumben Mahadevia, and where it used that case as the guiding principle for this case, and in the context of valuation of shares in case of a going concern. And since I have mentioned this case, it's a 1980 case which was referred in the Renuka Datla case. Very briefly, let me tell you that the Kusumben case, what the Supreme Court had said was that where shares in a public limited company are not quoted on a stock exchange, or shares are in a private limited company, the proper method of valuation to be adopted would be the profit earning method. So that was one way that in this case, we did see we had some visibility of how shareholder rights and control and premium were dealt with. Again, you gentlemen will find that these are very, very, I would say sporadic observations, not self-contained, backed by solid logic. Another feature, and again as we go along, you will find is that our courts have adopted a fairly hands-off approach to the when it comes to testing valuation analysis or valuation reports. Generally, the jurisprudence is that unless you are able to demonstrate that the valuer has adopted a fundamentally wrong method or committed a patent error on the face of it, courts will not step into the shoes of the valuer. It is recognized that it's not a exact science. There could be variations in the way valuation analysis is carried out, and courts have generally upheld the value the determination of the valuation experts unless it is shown that there are certain external considerations, patent illegality, non-application of mind. So that's the overriding feature. Now, one of the consequence of this is that if courts are deciding not to get deeper into these aspects of valuation, of course, then they are not also in the process adjudicating or contributing to the jurisprudence. So it's left in the within the world of valuers to how do they kind of work and determine their own analysis. Now the second case which I wanted to briefly discuss with you in the Indian context is again a 2007 case of the Supreme Court. This is the famous GS Sultania case. So this again came up after that. Now this case involved fair valuation of shares. So the challenge was that the SEBI and the merchant banker had not properly valued the shares of the target company. And the appellant who came to the Supreme Court who wished to exit from the company filed objections to this valuation, questioning the valuation done by the expert, which was Deloitte in that case, at rupees 43 per share. So that's where it started. What had happened previously in this case was that, and before it came to the Supreme Court, was that SEBI had appointed two independent valuers because disputes arose. So SEBI took a step, and then two companies which got appointed, and and then they compared the three reports and kind of came at a valuation. Now this was challenged in the Supreme Court that the party said that no, this valuation is not correct for various reasons. Now, the Supreme Court said that the current principles of valuation applicable to a given case is a pure question of law. Now, I would like you to pause here, and we do find even in this case later and other cases that you see the correct principle of valuation is not purely a question of law. It's a question of law combined with a question of fact. Simply because we do not have a legislative code here or legislative framework as to how valuation has to be done. By its very nature and by our legal framework, a lot of discretion and a lot of exercise of judgment is in the hands of the valuer. The valuer, of course, there are principles and there are methods by which that judgment has to be exercised. So if so, it may not be an accurate statement to say that it's a question of law, but that's what the Supreme Court said here. Then it said that, and this is relevant because one of the questions today I have is about valuation and shareholders agreement. Can parties agree or disagree, and what valuation? Now, this case does throw some light on that question. What it said was that the parties can agree upon a principle permissible under and recognized by law. So you can agree that, look, in a contract, this is how you'll do the valuations principle, which is recognized by law. And if there are two or more alternative principles which are equally valid and available, it might be permissible for parties to agree upon one of the alternate modes of valuation in preference to another. So, if you reflect this back to the question, if there are certain accepted, agreed, recognized principles of valuation, parties in a contract they are within the realm of liberty of contract to agree that how they would undertake this, how this valuation should be undertaken. This case is a little light on that point. Then, of course, this case went on to say that if a valuer adopts any recognized method of valuation, there should be very limited intervention by courts. So all they will look and try to ascertain is that did the valuer adopt, select, and apply a correct or a recognized method of valuation. I would not say correct because within the I mean, we know that within the methods of evaluation, there's an element of the discretion that the valuer has to select the most appropriate method, maybe more than one, then undertake the valuation, allocate weights to the various methods. So the court said that look, it has to be one of the recognized methods, and court would intervene only if valuation is fundamentally on an erroneous basis. Now, gentlemen, these words and terms sound very simple, fundamentally or on an erroneous basis. But let me tell you that these are very subjective tests and qualifications. What is fundamental? What is not fundamental? Is evaluation data fundamental aspect? Is are your projections, are your validations fundamental? What is erroneous? Really, there is a very fertile field left open, for it to be adjudicated. And as we go along, we hope that principles will emerge, as to what is fundamental, what is not fundamental. But as I said, the law has progressed very slowly in the Indian courts. So the Supreme Court said that courts would intervene only if the valuation is fundamental on an erroneous basis. And in by putting this test, the Supreme Court discussed that a control premium at a majority, what should it be, and at 76%, and it said that the values of control premium that we would attach at a simple majority and at a 76% shareholding would be different. So it did reinforce what we spoke yesterday, that the levels of control and the values of control premium at different levels would be different. This is also one of the questions today. So the principle has been recognized. Now, what would be different, and to what extent, and how much? Again, these are open things for us to kind of delve upon. And then the court said that if the valuation determined by the acquirer or his merchant banker agrees with the valuation of the series valuer more or less, then the company's board, the board of directors of the company, has no option but to accept the offer price of the acquirer. So that's basically again failing to intervene into the process. And then, as I said, we do find a conflicting observation in the judgment later, when it says that the correct principles of valuation applicable to a given case is a mixed principle of law and practice. I think this is a more accurate reflection of the reality. And then it involves complex and technical aspects. Yes, indeed it does. We discuss that. Then I think the court also went ahead and kind of gave a little bit of a very considerate observation on valuers by saying that, look, do not seek for mathematical precision or exactitude as attributes of share valuation. So it's not something that that is so precise and exact, and it should not be. That should not be the quest as well. It's the best opinion of the expert value. So that's where it. So in doing that, it again, re-emphasized and followed the principles of the Renuka Datla case. So this is the second case again, which throws some light of how the Indian law has progressed. Now, the third case, again, this was the case in the context of amalgamation of two companies. It is 1995 Supreme Court is the Hindustan case. And as I said, that valuation has come as a subset of various other larger corporate reorganization exercise in the cases that. This case involved merger of two companies, and it was challenged by the employees' union, stating that the merger was against public interest. And there were, in this case, involved shares, with where there were restrictive covenants attached to the shares, which are forming part of the amalgamation. So one of the companies which was amalgamating did have a share capital or the shares, and to which there were certain restrictive covenants. And again, the court took a very hands-off approach, and court held that the petitioners, the people who were the party which had come to the court, had failed to establish any fraud or prejudice. And on the valuation of share for the exchange ratio, that's where the valuation was relevant in the case. The court found that a well-reputed valuer would determine the rate by combining three well-known methods. That is the net worth method, the market value method, and the earning method. And said, hence, it is credible. It's credible. It's a very well-reputed valuer which has done this. So why should we get into it? And in while doing so, it did make some certain observations about the shareholder rights, and it said that look, a shareholder has no interest in the assets of the company while the company is in existence. So when a company is in existence, a shareholder does not have an interest in the assets, and this is again one of the questions which I have for later today, which we'll deal with. Only when the company is in liquidation that a shareholder may have an interest in the asset. May, and may is very big, may, because we know that in liquidation, in the order of preference and priority, the shareholder rights come are fairly below in the food chain. Now, then the final observations as a passing in this court had said was that look, the rights of shareholders basically, what are the rights of shareholders in a company? And it would include the power to reject directors, the right to vote on resolutions in meetings, enjoy profits if dividends are declared, and get the surplus of assets on liquidation. Basically, we discussed this yesterday. So these rights were kind of identified, cited by the court in this case. So that's the third case where the Supreme Court looked at valuation. And then we'll discuss two more cases, and then kind of move to the next subject. Then we had another case in the Supreme Court in 2006. This is the Western Maharashtra Development Corporation case. And here the party approaching the court, the petitioner offered to sell the shares to the respondent. And a dispute arose on the value of shares offered by the petitioner. And the arbitration was commenced. And arbitrator decided that the price of the shares and consequently it also decided on the relevant date of the valuation. So an arbitration award came as regards the valuation of shares to be transferred. Of course, this is the award that came in challenged from the lower courts and finally reached the Supreme Court. In essence, in this case, the court held, and again to the facts of that case, that 30% discount was reasonable and acceptable for lack of control. So a deal lock of 30% was indeed there in the valuation process applied by the valuers, which was again upheld by the Supreme Court. And then this case also brought out two of the other features which we discussed yesterday. That Section 9 of the old Companies Act of 1956, which is the Section 6 now, provides that the Act will override the MOA, or AOA, or any other agreement between shareholders. And if the terms of the MOA or these agreements are repugnant, they will be void. So this observation was also made in the Western Development, Maharashtra Development case. And in this context, the court said that the provisions of preemptive rights contained in an SHA or AOA must yield to Section 11A of the old Act. If we recall, Section 11A of the old Act dealt with transferability of the shares, which is now Section 58 of the new Act. So said that so the court said that look, if there are preemptive rights contained in SHA or AOA, you cannot take away what is there in Section 11A of the Act. So they have to yield to this Act. That means, in essence, re-emphasizing the principle that I spoke yesterday, that shares of public companies have to be freely transferred. So that was the fourth case, and then finally we'll take up one case from the at the High Court level. This is again a 2001 Mihir Chakravarti case, and here that there was a dispute between two shareholder cum directors on the board of the company, and the petitioners agreed to transfer his entire 33.33% in the company to the respondent. And In lieu of the transfer, they agreed to receive the value of the shares. Now, the valuation that was arrived for this transfer was the subject matter of challenge. And this is one of the cases where the courts came a little more harsh on the valuer, and it held that look, a valuer could be liable for tort for negligence in valuation, and valuation can be questioned in case of a mistake. The position of law seems to be that a valuer cannot claim immunity anymore if he acts negligently in making his determination, and can be sued for tort for negligence, but action against the valuer for damages cannot come when the court is considering the validity of the valuation. So what I'm trying to point out is that it is happening that now there is a thinking that look, let us kind of consider the valuation and the valuer's role and the valuer's analysis with a little bit of a more exact parameter. So that is one thought, and as we all know that it is this principle which gradually has moved and now found place in our the new Companies Act. So there are certain statutory roles and certain functions and certain consequences which are there. So that kind of puts a larger degree of responsibility and onus on the value. Then this case also said that, and this is true in law, that if parties may have agreed to be bound by a valuer's report, but simply because suppose in a shareholders agreement you say that okay, ABC will value the shares and the valuation is done, you agreed that that the valuation will be done by a identified organization, but simply because you have agreed, it does not preclude you from questioning the validity of the report. Now, you see, it's a very basic concept of law that if we in a shareholders agreement say that look, we decide that XYZ company will do the valuation for in case of a transfer or in case of an exit, and that a report will come. So of course both parties continue to retain all judicial remedies for that report, because we all know the basic concept of law that any agreement which exhausts legal remedies available to a party is not valid. So notwithstanding that we may agree a process, a procedure or an entity, but if the report does not kind of satisfy the requirements, or not the requirements, if it doesn't satisfy the tests, parties are free to kind of seek a judicial review. So that's broadly, some of the features of the Indian jurisprudence that has emerged in the context of shareholder valuation. I will now very briefly look at some of the very relevant and very controversial and very discussed about cases in the international realm as to how these cases and what kind of data they have generated. And one of the cases I wanted specifically to talk to you about is the Lawson Marden case. This is a case of the Supreme Court of New Jersey of 1999. Now, this case deals with the determination of fair value of shares by dissenting shareholders. Please keep this term in your mind as we go along. That it was how to determine the value of shares for the purpose of dissenting shareholders. Now, what dissent is or what dispute is a different aspect. And in this, the issue that the court was called upon to adjudicate was that whether a court should apply a marketability discount in determining the fair value of the shares of stock held by dissenting shareholders in a family-held corporation in the context of an appraisal action. So, family-held corporation, the dissenting shareholders while in determining fair value, should there be a marketability discount? And What had happened in this case in the facts was that the demand was made by the shareholders holding approximately 15% of the stock, and the company offered to buy the stock using a non-marketability discount of 25% on theory, but there was a limited because on theory there was limited supply of potential buyers. So when this offer of 15% was made, a deal arm of 25% was applied. Uh, the Supreme Court of New Jersey did go on to explain the concept of marketability discount, saying that the marketability discount, that is deal out, means adjustment for lack of liquidity in one's interest in an entity. Typically in a situation where there are limited supply of potential buyers for the stock. And minority discount means adjustment for lack of control over the business entity. Means non-controlling shares are not worth their proportionate share of firm's value because they lack voting power for corporate action. Now, in the court's view, and in that case, the court said that any rule that imposes a discount on the existing dissenting shareholder fails to accord to a minority shareholder the full proportionate value of its shares and enriches the majority shareholder who may reap a windfall from the appraisal process by cashing out on a dissenting shareholder. Courts took a sympathetic view, in favor of the minority shareholder. And what it also said was that such a rule, if you were to discount minority shareholder by applying T-law, it means that you would penalize the minority by taking advantage of the protection afforded by the statute. So you cannot be penalizing dissent. You see, it's again a US court, so the whole concept of freedom and how you are able to express. So at the shareholder level, if there is a dissent, do not put a penalty to the dissent. And so with this principle, the court then went on and said that, look, in the absence of extraordinary circumstances, a marketability discount should not be applied to the value of shares being tendered by a dissenting shareholder in the context of a statutory appraisal action. A court should apply this exception only when it finds that the dissenting shareholder has held out in order to exploit the transaction, giving rise to appraisal so as to divert itself value that it could not have made otherwise. Hence, the dissenters wanted liquidity for their stock and wanted to sell their stock in a corporation, and because they failed, or they lacked confidence in the management, and this is not an extraordinary circumstance which should require application of a discount to the shares, and hence the court refused to diminish the value of the fair share. And then court said that fair value entails fairness and equity in deciding whether to apply a discount in valuation of shareholders. And under the fair value standard, dissenting shareholders are entitled to their full proportionate share of the fair market value without any discount for lack of liquidity or market. So this is where this case rested. But let me tell you, gentlemen, that this particular aspect is an aspect of very intense debate as to application of discounts in fair market value and fair value. This is one judicial view which has been taken in the context, but there are many other divergent views on this aspect of how to apply and how to deal with discount. We encountered this case. The reason I talk about is that when we are talking of valuation, even at times in the context of shareholder actions before the NCLT or earlier the company law board, we have encountered this case. The minority shareholder rests on this case to say that, look, there is no Indian jurisprudence, but do not penalize our dissent by applying a discount. So that's one very interesting Yes, but again, there are a list of cases which follow from there here, which are also contemporaneous. I'll share that list. Surely this is not a complete discussion on the point. It's very interesting. Now, another case which from the international sphere, which I would like to take is a case by the again this is Supreme Court of New Jersey. It's a case of Casey versus Brennan. Casey versus Brennan. And what had happened was that this case involved a bank, and a bank with over 400 shareholders sought to reduce its number of shareholders so as to qualify for the subchapter S status of federal tax. So there was a status under which the bank had to go, so it required it to reduce its shareholders. So it did a restructuring exercise with the shareholder, for which it merged into a newly formed company and set out a cutoff level so as the number of shares needed to be held in order to remain a shareholder. Now, shareholders who had fewer shares or lesser shares than this cutoff would receive cash in exchange for their shares, and they cease to be shareholders, or they may purchase additional shares. So that's how they try to rationalize the number of shares and take that statutory protection. Now, the bank engaged in this case an independent financial advisor to make a cash fair market evaluation of approximately 20% of the bank stock. So that's how they, and obviously, by its very nature, this would attract dissent. So not all the shareholders approved the plan. Some shareholders filed suit to enjoin or resign the merger and to obtain a fair value. And a lot of dissent. Now, the initial stages, the lower court determined the price offered by the bank. That lower court held that the price offered by the bank was not fair for the minority shareholders, and the same view was also upheld by the appellate court. And and then in this case, when it came up, the court held that marketability discount should not be applied in determining the fair value of a dissenting shareholder share in an appraisal action in the absence of extraordinary circumstances. Therefore, it was concluded the lower court had correctly declined to apply DLOM or minority discount to the value of shares. The lower court also declined to consider including control premium within the fair value of shares. So this is again, and although let me just kind of point out here that although New Jersey has a statute that excludes from fair value any appreciation or depreciation resulting from merger, the court distinguished between the control premium and the inclusion of the value for anticipated future effects of a merger. Because the lower court determined that a control premium was prohibited as a matter of law, the appellate court concluded the lower court had erred in disregarding the valuations offered and offered to the lower court that had inherent control of premium, thereby reversing and remanding the case back to the court. So this is again one case where control premium was discussed, disallowed, then reversed back, and so the idea again is that this issue is is fairly live and subject of a very intense judicial debate. And in the context of valuation, and for you gentlemen and for us, this doesn't kind of leave us very comfortable, because you see, absence of clear-cut judicial, statutory, or contractual guidelines enhances the capacity for ingenious judgments for by experts, and experts would not like to delve in that, because more so when they are tested by these kind of severe standards increasingly in courts outside the country. Now, if I was to sum up the international law generally through various cases, if you want to draw some principles and try to list out that what is the international law on D law. Okay. Now, these are the 7, 8 things that courts have looked into as parameters and try to unmask these aspects in determining whether and the degree to which DLOM should be applied in valuation. obviously, the starting point would be the financial statement analysis. So they have seen, and then the courts would see that, would examine how have the valuation, how has the valuation exercise carried out this analysis. In that context, courts would also then look at dividend policy of the company. And we spoke of this, that a very strong dividend policy would make the shares more marketable. Then you need to look at the nature, history, and outlook of the company's management. Now, we all know operational history, management history, those kind of things are also looked at. And obviously, identify and cite the control that is passed in the transferred shares. What is the nature of control that is there? Now, also look at what are the transferability restrictions into the acquired shares. So, or into the shares that is proposed to be acquired. Now, as we spoke, these restrictions could be in law, could be in articles, could be in documents, but then this is again an aspect. Then, what are the holding period requirements? Some questions have spoken about lock-ins. That promoter lock-in. We know there are some statutory lock-ins, contractual lock-ins. So, what are the holding period requirements? Now, if a bundle or a batch of shares is subject to or bound by holding period requirements, obviously to that extent it is not liquid or marketable. And we did speak yesterday, the next factor was the base value. What is the base value to which you are considering application of the discount? So that's another. And of course, finally, one feature is the expected growth rate of value. End of the day, we are all talking of, how the shareholder value will move, grow, or is projected. So what is expected growth rate? So these are 8 or 9 tests, 8 or 9 parameters, pillars on which application of DLOC has been tested in the international jurisprudence. So with that, within the time, I would like to close the authorities, the jurisprudence part of it, and come to the sum up of our discussions. This is kind of some principles which we derive from these 2 days of interaction with you, gentlemen. And let's try to list. Let's try to kind of briefly identify these. First of all, lack of control and lack of marketability are distinct concepts, yet they are related. And we can all now find in the discussion how we spoke about it. Two different concepts, there is an underlying umbilical cord that binds these two. Second, non-controlling interest is worth lesser than their proportionate value and vice versa. Again, a principle which we are clear that if it is a non-controlling interest, it will be the value will be lesser than the proportionate value. If it is a controlling interest, the value may be greater than the controlling value. Basically, discount for lack of control or premium for the presence of it. Market, third principle, market generally pays a premium for liquidity and demands discount for lack of liquidity. Very simple. We need not expand. The principle on which DLOM rests. Fourth, the concept of DLOC and DLOM are very well recognized in the valuation world. And this is very important. Nobody, and whatever reading we do, or you gentlemen will do, nobody disputes the concept. Nobody disputes the rationale. Nobody disputes the need. It is the degree and the application of this in specific facts and circumstances which raises more complex and disputed issues. So conceptually, yes, but whether I should apply one or both, and the extent to which I should apply it in a particular set of facts and circumstances, becomes the disputed kettle of fish. This is where there is exercise of discretion, there's exercise of reasonableness, and the judicial interventions where all the fight happens. Fifth principle that comes out is that while DLOC and DLOM are separate concepts, they should be considered in conjunction with each other. Very important. If you are determining to a bundle of shares, you're trying to identify the discounts and DLOC and DLOM. They are not separate jackets. Look at it in conjunction with each other. Let's see how they're interplaying with each other. And of course, as we said, that these application of the discounts, they it becomes relatively easier in publicly traded companies. But while valuing closely held companies, gentlemen, it requires very due care, exercise of reasonableness, and very sound valuation judgment is necessary. So be very, very careful when you are dealing with closely held companies. And and how would you do that? You would do that by identifying, considering, and evaluating the particular facts and circumstances within which the subject entity is existing or operating. So please, from a valuation perspective, define the ecology of that entity, identify the various factors that we have spoken about, see the presence or absence of them. And so in a sense, what I'm trying to tell you is that it's not a straight jacket formula that this is what is there and we plug it and we get no. There are a bundle of facts. There are a bundle of circumstances or situations. You have to look at, first of all, as to what is relevant to your context. So pick up what is relevant and then try to put them in these kind of tests through the legal, contractual, regulatory, and the valuation principles, and try to carry out your analysis. Now, as I said, the legal and the contractual paradigm of the subject entity is extremely relevant. That means the law attaching to the operations of that entity, the shares of that entity, the regulations, the articles, and the contractual regime, both at the shareholder level and at the creditor level, at the lender level. What is identify that, put that in a basket, and see how they are attaching to the shares, its control, its marketability. Obviously, there cannot be a blind application of discount or premium in determining the value of an equity interest. It has to be analyzed to the facts carefully on case-to-case basis. Of course, you would have valuation precedents, you would have valuation principles, you would have certain existing kind of determining parameters which will help you. Those are your tools. But then please consider your facts. Now, having said that, what is it that what requires us to now exercise a greater reasonableness, a greater diligence, and a greater kind of expertise in this? You see, gone are the days when the results of your valuation is going to be exposed only to your client or to your subject entity or to your mandating party. We frequently find that the valuation analysis and the results now are tested by multiple parties at multiple external forums. It's not something you and your client. It will be tested before authorities, maybe income tax, FEMA, courts, and your report will come up there. It will be discussed. It will be analyzed. So keep the kind of various entities and audience which would be receiving your report. Particularly if you were to make a valuation on damages, your reports will be taken to court or arbitration proceedings. You will have to stand up. You'll have to defend your report. You will maybe cross-examined on your report, and these are done by fairly trained lawyers. And we also know that now there is a concept and very well recognized in India and abroad is peer review. Valuation reports are subjected to parallel reviews by other analysts. There are guidelines, there are frameworks which define how to carry out a review report. Now, the reviewer himself would or herself would be in tomorrow before the judicial court. So, one of the things that I'm trying to draw attention is that your report has to have a very strong degree of credibility and sanctity because it will has to pass. It may be required to pass at various levels of test to kind of stand up on its own. Now, what it means? It means that today the responsibility and the fiduciary obligations of a valuer is ever increasing. So you have to be very, very aware of these kind of, responsibilities, the onus that lies on you, and also because the consequence of default and negligence is getting severe. We all know the new act; it has certain provisions. We have had cases more in the U.S. where there have been penal consequences, there have been damages applied. So do exercise diligence, prudence, and ensure that there is absolute legal compliance in in your valuation analysis. So it has to be a very collaborative work between you, your subject entity, the data that you have, your team, your legal team, your analysis team, and they have to really kind of work in a very, very concerted collaborative manner to undertake this valuation exercise, more so in the context of shares, shareholder rights, or application of discounts in determining or ascertaining shareholder rights. So that's where I would like to end now. I had my limitation of time, so I tried to put something together for you gentlemen within the time that it was permitted. But of course, it will be my privilege to come again and talk to you on any specific aspect that you would want me to get into deeper, and we will find some time for that. At this point, I do have certain questions there. Some of these questions have come from yesterday, and I would like to first thank you, gentlemen, for participating and kind of being interactive with these questions. So let's briefly take these questions and see whether how does our analysis, how does our discussion provide insight to these questions. Now, one of the first questions that I have been asked is that shareholder agreements are dealt at par with articles of association in UK and other countries in cases of dispute resolution. True, yes. In the Indian scenario, as I had mentioned in my talk, the aggrieved party will have to go to a civil court under the Contract Act for specific performance, etc. The question is there any case law in India that the disputes are heard in NCLT/CLB and orders are made considering SHA? So basically, as I understand, the question is that you have a shareholders agreement, and what is your ability and to go to the statutory NCLT, which was erstwhile CLB. You see, I would like to say three things here. One is, I'm very certain that purely SHA disputes would go in the civil court, or in case if you have arbitration clause, it will go to arbitration. Simply because you are asserting contractual rights, you are claiming contractual reliefs. And the forum for that would be a court or an arbitration. Now, when we talk of contractual rights, they are contained in that contract. When you talk of relief, generally in law, we say that if you were to seek a relief from a breach of contract or a threatened breach of contract, as we call, you have two remedies. You may seek a specific performance of the contract, or you may seek damages. Again, very briefly, let me make a statement that specific performance of shareholders agreement is a very uphill task. It is not in the nature of an agreement which can be specifically performed. So your remedy really lies in the damages which you can claim in a civil court or arbitration. Now, having said that, the second point you have to keep in mind, and I had said this yesterday, that Contractual rights in the SHA are in addition to your statutory rights. So if you are a block of shareholders, which is more than the threshold of 10%, notwithstanding the SHA, whether it exists or not, you have certain rights in law and you have certain remedies in law. And as a 10% shareholder, you can go to the NCLT claiming operation mismanagement, or you can challenge the amalgamation, compromise, and all that. So these are statutory rights which are available, remedies which are available to you in law, and you can go to the NCLT, if not whatever may be the status. We do find, and that is my third statement on this question, is that in terms of the article of the shareholders agreement are incorporated in the articles, fairly we find the minority shareholder drags the other party for breach of articles, and that's a statutory is kind of a action. So in cases where the shareholders agreement is incorporated in the articles, the shareholder may indirectly try to assert those rights through the route of articles into the NCLT. So that's how I would like to look at that question. The second question that I have is now it's a I think can a shareholder agreement provide for minimum guaranteed assured IRR for investor in equity? My simple answer will be no. I mean, uh, of course, the gentleman who asked the question himself has pointed out that in case there are non-resident investors, the FEMA itself, the FEMA guidelines prohibit you from giving an assured or a guaranteed return. But even if there are domestic investors or shareholders, I have not come across any shareholders agreement where a shareholder is guaranteed a minimum return. To me, it goes against the very concept of shares. If you see your instrument is shares, it has certain rights and obligations in law. It has certain kind of privileges in law. We know that the law would override any contractual provision. No shareholder can kind of tell the other shareholder, and no shareholder will guarantee to the other shareholder any IRR. I mean, you sail or sink with the company basically. Now the third question is, please explain the manner in which DLOM is adjusted for tag along and drag along rights. Very good question. Let's talk about tag along. If a minority shareholder has a tag along right, what would it mean? It would mean that if a majority was to sell their shares to a third party, the minority has the right to tag along and sell shares along with the majority. So obviously, the presence of a tag along right in the hands of a minority shareholder enhances the value, the marketability of the shares of the minority shareholder. And hence it will reduce, other things being same, it will tend to reduce DLOM. DLOM could be less. So that's how I see it. Now let's see drag along. See, again, drag along is a little different kettle of fish. The drag along rights are generally given to a majority shareholder. That look, a majority shareholder actually, if it wants to pass on absolute control or transfer shares, it can drag the minority with it, and minority will have to go and sell it there. So the drag along rights of the majority shareholder, first of all, it will depend on the contractual terms, how it is and to what extent is it enforceable. But if you are valuing the majority, it will enhance the control premium, because if this right is enforceable, then the majority contractually has the capability to deliver absolute control by dragging the minority as well. So in the hands of a majority shareholder, a drag along right could be a valuable right. But if you are valuing from the perspective of the minority shareholding, then the same drag along right places a severe limit to the marketability and control. I mean, the status of a shareholder who can be dragged to sell and forced to sell at the will of the majority, I mean, what is his own marketability and control over his own shares? Hence, DLOC and DLOC could become very significant in your assessment. That's how these rights operate. Now, the a very small question there. how the differential voting rights attached to shares are dealt in valuation. Again, I think if these differential voting rights can control major corporate actions, then the control aspect will be enhanced and the level of delock could be conservative. So really, I cannot answer this question, in vacuum. But if I was to look at that, what kind of these rights are, and cumulatively, how do these differential voting rights add up to, and what impact would it have on major corporate action, then it could enhance, you know, the the control, and LELOC would be then a little more conservative. Now, the next question which I had was that how can we legally justify the premium amount? Now, I'm sorry if I'm unable to understand this question, but as I see it, there is no legal definition of premium amounts to be applied. I mean, we do not find it in a statute or a law or a book. Look, this is how you apply this. I mean, there are certain factors that need to be kept in mind when you are evaluating, assessing the applicability and degree of the premium. And we spoke of some of the factors. But let me tell you some tests, which could be, legally, which may be relevant. First is that the premium should be commensurate with the control that the shareholding reflects. So there has to be a correlation between the premium that you are assessing and the control that is being with it. It should be comparable. It should have some kind of visible comparability within the industry that you are dealing with. It should be reflective of the business and the value of the underlying company. And then it should apply on a rational, justifiable basis on the facts of the entity. I mean, this is how you would like to, I mean, you should be approaching it, but we do not find a legal straitjacket kind of formula here. Now, the next question that was referred by one of our participants is, in cases where the shareholder agreement has a non-compete condition, is there any settled jurisprudence on the applicability of the non-compete conditions? How long can such conditions survive after shareholder exits? Strictly, this is not a question of valuation, but it's a very good question. And again, it's a very relevant question in the Indian context that we all talk of non-compete, non-solicitation, and those kind of clauses. What is the legal sanctity? How do they operate? What tests to quote to employ when they look at these clauses? You see, keep in mind one thing, that non-compete provisions in SHA are common. It's not something which is uncommon. It's there, and take it from me that it's legally enforceable also. So that's the starting point. There are sufficient legal and judicial precedents in international law, more in international law and also now in Indian law, which say that these kind of provisions can be enforced. But in Indian law, when you talk of enforceability of non-compete, courts have applied two tests. And this again, when I say this after looking at the myriad of cases. The first test is that the non-compete, non-solicit, or whatever restriction you put, it should be reasonable restriction within the facts and circumstances. So suppose in a shareholders agreement, I say that no, you are not going to tomorrow. One shareholder will not go back to and stay in with his family for 6 months. I mean, it's something absurd. But if a shareholder says not set up a parallel business for a period of time, or I will not take this client or whatever, these are relevant to the context. So the restriction should be reasonable within the facts and circumstances. It should not lead to a restriction to trade. That is one test. And the second test is that there should be sufficient identifiable consideration in the contract for the party to accept such restriction. That means Suppose if you say that, fine, it's a shareholders agreement, we are pooling in, and this is how we run the company, this is how my business plan. So there are benefits in being shareholder of that company, which the shareholder perceives. And in lieu of those benefits, they constitute sufficient consideration in the hands of the shareholder to stand up and assume these restrictions. So there has to be a correlation between the value, consideration, and the restriction. It should not be in vacuum. So with that, I think that we can say that there is no legal limit to the length of the period. It should meet these two tests. It should be reasonable, it should not lead to restriction to trade, and it should be for a correlated consideration. That's how I would like to look at it. Now, the next question, I think we have answered this. What are the dependents that impact DLOC while applying? We have discussed this in detail. I mean, we discussed things like supermajority, judicial remedies, terms of the articles, potential dilution, preemptive rights, contract restrictions. These are the public or private companies. So these are the various, I would say, dependents on DLOC which you apply. And I would share my presentation paper also with you. You will find these there. So that's not an issue. Again, a question that what are the key points? What are the key points need to be covered in SHA with perspective of exit valuation of private equity investors for unlisted company? Hmm. Yeah, exit. I mean, private equity investor exit is music to their ears. I mean, when they negotiate a contract, they spend more time in sharing the exit than kind of deciding the stake. That's anyway. But typically, you see how we find it is the contracts have these kind of provisions. It will provide for independent registered valuer who would undertake the valuation. So you will identify the the valuing entity. You may identify or select the valuation methods or principles which you can stipulate that. Now, there's some degree of comfort with the new Companies Act. So there's some legal protections there. You may seek expert assisted arbitration in case of disputes. So these are the kind of 3, 4 ways that exit valuations can be kind of addressed in the shareholders by the private equity investor. The next question is that somebody has asked me to share a small summary of what are the points which should be mentioned in SHA when private equity investor invest in the company, and what are the general mistakes and all that. Now, we have again covered this in our discussion, but broadly, let me tell you, from a private equity investor point of view, anti-dilution and preemption rights, minority protection, definitely, board representation, along with stipulation of quorum requirements. So, presence of the nominee director is necessary to constitute a quorum, maybe even at the general meetings. Business plan control and warranties around the business plan. Then very credible warranties and indemnities from the promoters as regards the business and operation. Information and inspection and audit rights. Then, of course, the exit provision tag along, you can put to the promoter. Now, we can, I mean, this is again, I mentioned this call and put options. This again is a huge legal issue. And we can, at some point of time, if we need to talk about it, we'll talk about how they've evolved in Indian law, what are the enforceability around calls and put options, what are the limits of these calls and put options. And this is again a very exciting topic. Then the private equity investor may lock in the top management, say that, look, you will be the CMD, you have to devote your time. And then, of course, arbitration remedies and all that. So typically, these are the ways that they look at it. Now, the next question is that can you share some court cases in which we can get some guidance of how the data which was reported in valuation report impact the final judgment in the court cases, including international cases? You see, yeah. As I understand that you have used a set of data in your valuation, and the question is that how would the courts look at it? Again, and as you said that there are more, I mean, I can share with the names of the cases in a separate list, but let me share the principles and more from the international law. First of all, the source of data should be credible and it should be validated by the subject entity decision making level. So it's a board or whatever, management committee. The source of data has to be validated. You have generally independently assessed the data, plausibility tests. I mean, what are these projections? So there is an obligation on the valuer defined in various guidelines. So you have to independently assess the data. And again, this is I find it in some cases, but it's very fairly. Data should not be tortured in the valuation process. Please have the integrity, retain the integrity of the data. Your data selection, data rejection, or whatever subsets you create should be on sound and reasonable principles. And finally, the quality of data. It should be representative both for the across the company and over a period of time. So these are some of the tests that we see around data and which is used for valuation. Now, I have three more questions. The next question is that what is the legal position of public shareholders or retail shareholders of the insolvent listed company, it is or resolved company and its related case law? You see, it's a very simple question. For a company under the IBC and under an IBC-driven resolution, CIRP process we call it, the retail shareholder will be dealt with within the resolution plan to be approved by the creditors. So basically, if you're a small shareholder, marginal share, whatever, and the company is in insolvency in the resolution process, you may be required to sell, or your share may be acquired by the resolution applicant if the resolution plan is approved by the creditors. So you are at the mercy of the creditors really at that stage. Now, the second stage you said was that the company is in a liquidation process. Now that means if the liquidation process is either it's through the IBC or whatever. Now, if that is so, then you will simply be standing in the line in the array of claimants to the asset. You will be listed below the creditors and the statutory liabilities, financial and operational credit. Everybody will be ahead. You will be one of the claimants to the residual assets which would be realized in liquidation. Bad news. Now, I do have, I think that's my last. I do have 3-4 questions which are purely from valuation aspect. We have spoken about settled industry tariff of controlled premium, then liquidation preference rights and those kind of. Now, I did look at these questions. We can get into it, but I think it will be appropriate for me to defer to our valuation experts to deal with these questions. I will discharge my responsibility by transferring these questions to the team and see that they will be taken care of in their coming presentations. And if there are any other questions, because we are now kind of at the close end of the time, if there are any other questions, gentlemen, please feel free to upload it. We will provide you with the answers. I will share two things with you. After at the end, I'll share my presentation format with you, and I'll also share with you a fairly wide reference list for further reading. These that we get together to talk, and within that we try to exercise our own, judgment to see what is relevant. What I thought is relevant may not be so relevant for you. So it's always important. It's fascinating if you were to look at those reading material, find time and get deeper into it, and we could then have a more bilateral discussions at various stages and forums. So with that, thank you so much. Thank you so much, everyone, for being with us for the last 2 days. And I sincerely hope that it's been a useful session. And I look forward to interacting with you at the next opportunity. Do remain well. Do remain safe during these times. Thank you, gentlemen.
Thank you, Ochaji. Thank you very much for joining us and accepting our request to be with us for 2 days, even extending the session.
These sessions were really enlightening, and I'm sure the participants would be able to link the legal side of valuations to the kind of examples and cases you have shared. So thank you very much, and wish you and your family also safe travels.
Thank you. Thank you, Dr. Sirovi. Thank you very much for providing me the opportunity. Thank you.